I'm very pleased to briefly present the primaries for judges on competition law and economics for ASEAN Judges. At the OECD, we do hope that this can be a useful set of short information sheets that judges from ASEAN, but also from other parts of the world, can consult when they are dealing with a competition case in their courts. The primaries were developed by the Federal Court of Australia in close cooperation with the OECD during the first half of 2018, and they were launched in the October meeting of the 8th OECD KPC Competition Seminar for Asia-Pacific Judges in Jakarta, Indonesia. The primaries, therefore, brings together the Federal Court of Australia in-depth technical knowledge and experience of the OECD and the OECD's international work with judges in the competition field. Together with its experience working with courts from around the world, the OECD has brought to these primaries its extensive knowledge of the ASEAN region in the competition arena. In this regard, we are very proud of the valuable work being done by the OECD Korea Policy Center, now for more than 14 years. As you can see from the website, these first primaries cover a variety of topics in economics and competition law: circumstantial evidence, expert evidence, abuse of dominant position. As a former enforcer and judge, I personally feel that these are among the topics raising challenging issues when competition law cases are litigated in courts. The primer on economics sets out the main economic concept that judges apply and parties advocate in competition cases, and thus aims at narrowing the communication gap between economists and courts. The primer on circumstantial evidence sets out the role that such evidence frequently plays in establishing often challenged facts and their interpretation, and discusses the different types of evidence and their probative value. The primer on expert evidence discusses the role that such evidence can play in competition law cases, and also offers insights into the experience of judges in Australia. Such evidence is often essential in deciding in court cases, but at the same time raise a number of issues that judges should be aware of. The primer on abuse of dominance discusses the concept of substantial market power and the types of evidence that may be used by judges to assess dominance and to establish abuses. These concepts are based on complex economic models and the legal tests applied to alleged anti-competitive conducts are often challenged in court. To conclude, I do hope that these primers will be useful for judges as a consultation source when dealing with competition cases. Competition is a complex topic that many judges do not deal with very often. And having also served as a judge on the Cour de Cassation in France, I believe that these information sheets can make the task of judges much easier. Thank you very much.